Greetings. My name is Nikichi Taifa, and my presentation is Black Panthers, Just Us, and Miss Pearl, the makings of a movement lawyer. I'm really honored to be a keynote speaker for this annual HBCU pre-law summit, and I thank Attorney Evangeline Mitchell for inviting me back. The preface to my memoir, Black Power, Black Lawyer, My Audacious Quest for Justice, includes a heartwarming question from my then 3-year-old daughter. She said, Mommy, did you get Rosa Parks out of jail? Lord have mercy. Can you believe that gem of a question? That was indeed a mommy moment. No, baby. I was just 1 year old when Rosa Parks went to jail. But my sisters and brothers, there was a movement that not only got her out of jail, but put in space a set of circumstances that changed the landscape of America, and that was Black Power. People often ask, just what is it that shaped and molded me into the lawyer I am today? And I've got to state unequivocally that it was the era in which I came of age, the era of Black Power. There was a poster tacked to the bulletin board of my 8th grade 1968 junior high school classroom, Black Studies, of a Black man with a black beret on his head, with a gun in one hand and a rifle in the other hand, and a spear in the other hand, sitting in a Grand Slam wicker chair. And all the teenage girls in my class were giggling about how fine, how cute this brother was. But I kept asking the teacher, well, why is he in jail? And why is he being represented by white lawyers? Granted, progressive lawyers, radical lawyers, movement lawyers, but I'm asking, where are the Black lawyers to represent Black people? And around age 15 and 16, while in high school, I remember every week adorned in my signature style, tight bell-bottom blue jeans, platform stacked heels, a midriff tube top blouse, a huge towering African gele on my head, gold hoop imitation earrings, racing to catch the bus down Georgia Avenue, past Howard University, to the Black Panther office, which at that time was located at a storefront on 7th Street. And the brothers and sisters were carrying on PE, public education, political education classes in the larger back office. However, I always used to just stay in the front office, sitting on the lap of that fine brother who was pulling security. And every Saturday, I would meet the brothers and sisters downtown in front of Soul Shack, 13th and F Street, or in front of this little earring store on H Street, and help to sell the Black Panther papers. And I remember reading in the Panther paper about the 1969 murder of Chicago Black Panther leaders Fred Hampton and Mark Clark in their beds, and the lies and the fabrications of the police department afterwards to cover up their assassination. Please go see the movie Judas and the Black Messiah if you have not already done so. Okay, yeah, it's Hollywood, but there's some truth in it about those times. You see, over 50 years ago, I knew about the Panthers because they made the front page news, but I didn't know about the horrific 1857 Dred Scott decision, where a United States Supreme Court justice stated that, quote, a Black person in America had no rights, which a white person was bound to respect. 50 years ago, I didn't know about the 1822 trial of freedom fighter Demar Vesey, who masterminded one of the most elaborate slave insurrections in history. I didn't know about the case, the libelants and claimants of the schooner Amistad, where in 1841, international law was applied in a domestic court in the United States and served as a springboard to release kidnapped Africans. I knew nothing of the trumped up court trial of the Honorable Marcus Garvey or the inflammatory case of the Scottsboro Boys. And I surely had never heard of the phenomenal Black legal giant Charles Hamilton Houston, and his cautionary tale that if a Black lawyer was not a social engineer, he was nothing more than a parasite on society. But in high school and college, I did study about and learned, and I lived through the cases of the Wilmington 10 who were framed for the bombing of a grocery store in Wilmington, North Carolina. The case of the RNA 11 who in 1971 were herded through the streets of Jackson, Mississippi, half naked, barefoot, and in chains for exercising self-defense after their official residence was attacked. The Attica brothers case, where a prison in upstate New York erupted because the state refused to provide prisoners with basic human needs. And then the state turned around and murdered both the prisoners and the hostages. I did know about the case of Angela Davis with her characteristic large afro, her clenched fist. We all know the name of Angela Davis, but few people remember anything, if at all, about her once co-defendant, Ruchell Magee. Ruchell Magee, who is still in prison in California today. He is over the 60-year incarcerated mark behind bars. My college days in the mid-70s were the days when we as students immersed ourselves in issues involving the divestiture of corporations doing business in apartheid South Africa and trying to educate actors and athletes to support the cultural boycott of South Africa. This was during the time of repressive no-knock law enforcement legislation in DC, where the police could virtually knock down your door without a warrant. Still facing that today, Breonna Taylor. And it was the time of the FBI's once secret counterintelligence program, codenamed COINTELPRO, against the Black movement, targeting people such as Martin Luther King to Stokely Carmichael, Malcolm X, Muhammad Ali, the Black Panther Party, to name just a few. And in the FBI's own words, the purpose of the COINTELPRO was to expose, disrupt, misdirect, discredit, and otherwise neutralize the activities of Black nationalist organizations and groupings and their leadership, their spokesmen, their membership, and their supporters. Yeah, we didn't really rap in those days, y'all. But permit me to share just an excerpt from a piece that I penned and often recited, and it goes something like this. COINTEL's got Blacks in jail. They open up our mail, tap our phones and kick our bones and railroad us to jail. Angela Davis, Reverend Ben Chavez, Hasata and Geronimo too. Ruchell Magee all wanted to be free from you know who. FBI went so low they invented COINTELPRO to stop the rise and fire of a Black messiah who could unify and electrify Black people to revolutionize. Co is for counter, which means to use against. Intel is for intelligence. Pro is for program. They thought it was the perfect solution. Counterintelligence program to crush the revolution. Geronimo G. Jaga Pratt was in prison during this time, a former officer of the Black Panther Party. One of the main reasons he was in prison was because he could not provide an alibi as to his whereabouts at the time a woman was being murdered on a tennis court in Santa Monica, California. Well, he had an alibi, a stone solid one. He was attending a Black Panther Party meeting at the time, over 200 miles away. But that did not come up in court. Why? Because of COINTELPRO. The Panthers were at each other's throats. Geronimo himself had been excommunicated, and Huey P. Newton ordered that no one assist him in his trial. But even more sinister was the fact that the government itself knew and could prove that Geronimo did not commit the Santa Monica tennis court murder. Yet, the FBI refused to provide that evidence to the defense. You see, because of COINTELPRO, wiretaps were made and kept of all meetings of the Black Panther Party, and the meeting Geronimo was at on that fateful day was no exception. but it took a judge, Judge Walter Dickey, nearly 30 years later, a judge who may have been a child or a teenager, I mean, I don't know, at the time of Geronimo's first trial during the early 70s, to look at all of the evidence and to finally set him free. Well, while in college, I worked on the Legal Defense Fund and became chairperson of the National Committee to Free the RNA 11 men and women, one who was only 15 years old at the time, who were part of a group calling itself the Republic of New Africa, which advocated for the creation of an independent Black nation in the South. If you never heard of it, Google it, Republic of New Africa. Professors such as Derek Bell, you hear a whole lot about critical race theory these days. Well, Derek Bell was one of the architects of critical race theory. James Turner from the Africana Studies Department at Cornell University. They were all on the letterhead of this defense committee. Congresswoman persons such as Ron Dellums and Charles Diggs and John Conyers. You know, if you don't know these names, Google them. Ministers such as Ishaka Musa Barashango, Reverend David Eaton, Louis Farrakhan, political scientists such as Dr. Ronald Walters, cultural icons, Hakeem Matabuti, the list goes on and on. They all lent their names and their support to this defense committee. And while working on the legal defense, and mind you, I was not even a lawyer at the time, but I visited some of the most notorious prisons in the US at that time, including the infamous Marion Penitentiary in Marion, Illinois, Leavenworth Federal Penitentiary in Kentucky. I met with Imari Obadeli, one of the leading defendants in the case, president of the provisional government of the Republic of New Africa, who after his release from imprisonment went on to receive a PhD, later becoming a professor. I met with Sundi Ata Akoli in prison since 1973, where a car where he and Asada Shakur and Zayd Malik Shakur were traveling in was stopped and after being racially profiled on the New Jersey Turnpike. Sundiata is still in prison today, having served nearly 50 years, 84-year-old elder, COVID-19 survivor, early stage dementia. Take out your phones right now and type in the website. Take them out. Type in this website, www.sundiataAkoliFC.org. That's Sundiata, S-U-N-D as in David, I-A, T as in time, A. The next word, Sundiata Akoli, A-C-O-L-I. FC stands for Freedom Campaign.org. Sundiata Akoli FC.org. Sign the petition on the website for his release. Make a difference. You can do that right here, right now, today. The first time I visited Sundiata Akoli in prison, I was not even in law school at the time. I'm nearly retired now. Hashtag bring Sundiata home. Hashtag bring Sundiata home. So when I did get to law school, of course, I joined BALSA, the Black Law Students Association, and I began to ponder the intellectual challenges. How can we stimulate the ability to invent new ways by which the law can address a variety of substantive issues facing today's society? What was needed, I surmised, were strong, innovative lawyers who were not afraid to think outside the box and push the envelope to achieve change. I knew I would not be a lawyer who would be chained to a desk because I loved the cutting edge. And as an aspiring lawyer, I felt the responsibility to use the research, the writing, and the advocacy skills that I was learning to challenge injustice. I've done a whole lot over the years, y'all. And back then, when I was first starting out, I often wondered just what my substantive area niche would be. Would it be education and youth? Would it be employment discrimination? Would it be police brutality? What about academia? It ended up being criminal justice. For decades, a thankless, unpopular, and misunderstood arena. Mass incarceration, the war on drugs. Nothing has contributed more to mass incarceration of people of color than the war on drugs. Is this ranting and raving? Absolutely not. There was a police supervisor who once said that there's as much cocaine in the Sears Tower or in the stock exchange as there is in the Black community. But those guys are harder to catch. Those deals are done in office buildings, in somebody's homes. But the guy standing on the corner, he's almost got a sign on his back. Those guys are just arrestable. So what happens? Instead of deploying officers in long-term arrest of suppliers that after 3 months may only result in the arrest of Charlie and Harry, the decision is made to deploy those same officers to the Black community, to Tyrone standing there on the corner, and make 200 arrests. Despite the fact that arresting those 2 white guys in the suburbs may have shut down 5 or 6 crack houses, what do the police and prosecutors and politicians say? They say that they are responding to my elderly neighbor, Miss Pearl. Miss Pearl, who lived on the corner where I used to live. We all have our Miss Pearls. They're peering from their windows, peeping out the Venetian blinds. They're sitting on their porches and the stoops. They see everything that is going on. And the police say that they come to the community in militarized full gear because Miss Pearl would call them and expected that. They say that she wanted them to immediately make those 200 arrests in her community, that she didn't want to hear nothing about no 2-month investigation. So I pondered, why did Miss Pearl not want to hear about it? Is it because the correct message had not reached her? Is it because she had been inundated and captivated by erroneous media depictions? And because the media did not focus on it, she did not know that those 2 arrests in the suburbs may have shut down the crack houses in her community? You see, Miss Pearl and many of us just did not understand just what a mandatory minimum sentence was, that it didn't matter if college student Kimba Smith got caught up with the wrong guy and he beat her and threatened her and her family so bad that she was scared to come forward about his drug dealing. Google her up, Kimba, K-E-M-B-A, Kimba Smith. It didn't matter that she's pregnant when thrown in prison. It didn't matter that she never used or handled any drugs. The mandatory minimum drug law said that she had to serve time, 24 and a half years of it. There are no mitigating or extenuating circumstances when it comes to mandatory minimum sentences. Back in the day, Miss Pearl didn't understand what the infamous 100-to-1 ratio meant, that the boys in the hood who were convicted of selling 5 grams of crack cocaine, the weight of a couple of packs of sugar, worth perhaps $125, received a mandatory prison term of 5 years, whereas he took 500 grams of powder cocaine worth nearly $50,000 to receive that same 5-year sentence. She did not know that 1/3 of all federal cocaine cases involved an average weight of just 52 grams, the weight of an ordinary candy bar. She didn't understand that Tyrone was not a major drug kingpin and the federal government had no business in his prosecution. And she did not know that the building of prison beds were predicated upon the test scores of little Black boys in the 3rd grade. And guess what? Miss Pearl never even stopped to think of the impact on political empowerment in the Black community as a result of 250,000 African-American men being disenfranchised as a result of their felony conviction, stripped of the right to vote. Indeed, she did not realize that every social issue was impacted, exacerbated, and or magnified once one is released from prison. Ms. Pearl was ignorant of the termination of parental rights under the Adoption and Safe Families Act of 1997, the loss of school loans under the 1998 amendments to the Higher Education Act. She didn't know that her grandson could have her kicked out of her public housing as a result of his drug conviction, that her daughter could be denied public assistance, or her son unable to find unemployment because of that infamous box, "Have you ever been convicted of a crime?" Indeed, It never dawned upon her that a juvenile justice youth could be sent to Harvard University for the cost of what society pays for his incarceration. Now, Ms. Pearl knew about the 13th Amendment to the Constitution abolishing slavery. She was unaware of the prison slavery exception clause. Neither slavery nor involuntary servitude shall exist except as punishment for a crime. So during the height of the war on drugs, with mandatory minimum sentences firmly in vogue, shocking punishments of 10, 20, 30 years and life imprisonment for drug offenses were normalized and hardly raised an eyebrow. But these commonplace sentences snatched mothers from children, men from loved ones, and furthered the destabilization of families and communities. Ms. Pearl did not know about the short and long-term trauma experienced by over 2.7 million children with a parent in prison. She did not realize that the mere presence of school resource officers in her granddaughter's school leads to a spike in arrests in schools, that schools with them had nearly 5 times the arrests as schools without. Finally, Ms. Pearl did not realize that year after year, decade after decade, century after century, although the players change and the script shifts, the script unrefutably remains the same: unequal justice. Doesn't matter whether the issue is vigilantism or police brutality or prosecutorial abuse or unjust sentencing. As a race, Black people have been subjected to a double standard of justice. The names, the groups, the events spanning the decades are legion: Eleanor Bumpers, Michael Stewart, Amadou Diallo, Abner Louima, Johnny Gamage, Troy Davis, Oscar Grant, Trayvon Martin, Michael Brown, Eric Garner, Aiyana Jones, Freddie Gray, Lakia Boyd, Sandra Bland, George Floyd, Breonna Taylor, Ahmaud Arbery. The list is endless. Ms. Pearl thought what was happening with the police was justice, where in actuality, it was just us. I spent over 30 years working on criminal justice reform issues. During the early 90s, I remember walking the halls of Congress, lobbying against the various crime bills, which culminated in what I unaffectionately called the granddaddy of all, the crime bill of 1994. What did it do? This bill featured the largest expansion of the federal death penalty in modern times, the trying of 13-year-olds as adults, the gutting of Pell educational grants for prisoners, the evisceration of the exclusionary rule, the gutting of habeas corpus, the implementation of the federal 3 strikes laws, the refusal to address the crack powder disparity, and money, monetary incentives for states to lock up more and more people for longer periods of time in exchange for loads and loads more money to build more prisons. And when the 1994 bill passed, there was this news item that happened to catch my eye. It stated that there was this prominent securities analyst in Virginia who spent a weekend combing through every detail of that federal crime bill and watching the debate on C-SPAN. And he then came up with what he called a list of theme stocks, the stock market for the 90s. And what do you think his highest recommendation went to? It was none other than the Corrections Corporation of America, which at that time was the nation's most successful operator of private prisons, whose stock had recently hit an all-time high. And in fact, the chief financial officer of CCA was quoted as saying, and I'm quoting, he said, "The crime bill was very favorable to us." I was shocked. I was absolutely shocked. Why? Because it smacked me in the face that we have a situation where the deprivation of liberty is powered in large part by the profit motive. We have a situation wherein there are economic interests in keeping sentences harsh and long so that prison populations continue to soar. And the scary thing about it all is that we have a situation wherein prison business may seek high occupancy rates more beds in the prisons, even in the absence of demonstrated need, even when it's not even necessary. From a management point of view, a prison can be characterized like a hotel or a motel. You want to fill every bed every night. And if you don't have enough guests, you do whatever you can to get them, including supporting campaigns for longer and mandatory minimum sentences. We're talking about a perverse profit incentive to arrest more people, convict more people, incarcerate more people, and for longer periods of time. And it starts with the presence of police officers in our schools, known as school resource officers. A seemingly benign title, but don't get it twisted. These are cops, and they simply have no business in our schools. They are the first step down the slippery school to prison pipeline slope. The out of control growth of the federal prison population is forcing cuts in education and job training and other social services, the very programs that address the root causes of crime. So it's not surprising that we see the advent of more and more punitive criminal punishment laws, which has caused the rate of incarceration of Black folk to astronomically rise. And although today the laws are quote unquote facially neutral and do not intentionally discriminate, disparate treatment is often ingrained within the structural fabric of social institutions, allowing discrimination to occur even without the need of action by a specific person. You see, today's racism is subtle. Well, it was, let's say subtle and structurally embedded, yes, in many police departments and prosecutorial offices and courtrooms. It's found in laws that look fair, but nevertheless have a racially discriminatory impact. The long-range implications of what is increasingly being called the criminalization of a race is shuddering. Massive incarceration with lengthy sentences invariably results in the disruption and disintegration of families, the destabilization of communities, and diminished life prospects, measures which combine to incarcerate generations. Any consideration of the impact of mass incarceration that fails to take into account the role of institutionalized racism is an insufficient analysis, and any remedy that does not acknowledge the understanding that racism manifests in various forms is deficient. It is past time that we confront the disastrous policies of the past half century. Today, there are over 2 million people behind bars. This country's mammoth experiment in mass incarceration has been an abysmal failure, producing conditions of life calculated to bring about the destruction of a race. Kudos to Michelle Alexander for popularizing the analogy of today's system of mass incarceration with earlier systems of social control, such as Jim Crow. Yes, we are talking about the institutionalization of second-class citizenship once one is released from prison. Yes, we are talking about disparate treatment and profiling, arrest, and sentencing. But guess what? We may also be talking about the possible extermination of generations as well. Although enlightening, I say we must not get too comfortable with Alexander's Jim Crow analogy to mass incarceration, as it just may be too limiting. I say that we must push the envelope even further to further illuminate the severity of the problems facing Black communities. You see, I coined the arguably contentious phrase institutionalized genocide as a framework through which to analyze the evolving jurisprudence of international human rights doctrine to selected conditions impacting Black people in the United States. Institutionalized genocide. The terminology is neither rhetoric nor radical ranking, rather it methodically uses the international and US adopted definition of genocide as a lens to scrutinize today's criminal punishment system and its impact on Black communities. You see, this is why being a lawyer as a Black person or other person of color is so pertinent. would the American Constitution Society have published my article explaining my concept about institutionalized genocide, racism in the criminal justice system, institutionalized genocide, if I had not been so credentialed? I take the internationally accepted definition of genocide and I juxtapose it against the impact of the criminal punishment system on Black people. The international definition includes not only killing members of the group and causing serious bodily and mental harm to members of the group, but it also includes inflicting upon the group conditions of life calculated to bring about their destruction in whole or in part. Perhaps, I submit, the heightened nomenclature of the term genocide will shock the public into sparking a real revolution in criminal justice policies and practices, as opposed to settling into yet another shift in focus to a still newer system of control. And perhaps we may need to push the envelope a bit further and ask, can the United States government abide by the mandates that a global framework to justice issues presents, or are we once again relegated to Dred Scott justice, where the human rights of African descendant people are not bound to be respected? Unfortunately, my elderly neighbor, Miss Pearl, passed before I could tell her about my work in the successful passage of the Second Chance Reentry legislation, 2008. She passed before I could tell her that the Fair Sentencing Act of 2010 that I've been working on for 17 years finally became law, which reduced the 100-to-1 ratio between crack and powder cocaine. She didn't get a whiff of the winds of change from the horizon. She didn't know that the narrative on crime was shifting and that criminal justice reform was not the lightning rod that it once was decades ago. She missed the 2012 Supreme Court ruling in Miller, which held that mandatory life without parole sentences for children violates the Eighth Amendment's prohibition against cruel and unusual punishment. She didn't know that the litany of Supreme Court cases in this area looked to international law to support its conclusions. Ms. Pearl didn't get to hear that former Attorney General Holder's smart on crime policies focused federal prosecutions on large-scale traffickers rather than Tyrone and bit players. She didn't know that President Obama would be the first sitting president to visit a federal prison. And she didn't know about his executive clemency initiative, which I helped to mobilize to provide relief for those serving inordinately lengthy mandatory minimum sentences. It's a new day and a new narrative being formed. But although Ms. Pearl did not witness the dawning of this new day and is unable to help shape this exciting new narrative, you and I can. We are now at a point where we can openly discuss the data that we have all known for years, that sending people to prison and keeping them there for unconscionably lengthy periods of time does not make us safer, does not deter future crimes, and does not promote successful reintegration back into our communities. Future lawyers, we need to find better, more creative, more cost-effective ways to push the envelope to achieve change. Future lawyers, we need to raise the ante and have the audacity to advance creative solutions. The Miss Pearls of our communities are crying out for you to take your place in continuing the struggle. So my life, my entire career has been that of the public interest movement lawyer. And my criminal justice reform has just been one slice of it. I've also been one of the most ardent and vocal proponents of the issue of reparations for Black people. I've consulted with city governments and big industries. I've dealt with voting rights, litigated employment discrimination, lobbied for law enforcement reform. I've represented political prisoners, advocated for posthumous pardon for the unjust imprisonment of Marcus Garvey from the 1920s. But you don't have to take my path, y'all. You don't have to be a movement lawyer to make a difference. You can be at the apex of the most lucrative law firm in the country, or work at the most modest legal service provider organization, wherever, regardless of where your legal career path takes you. You nevertheless have the responsibility to put the research, writing, and advocacy skills that you're learning in Evangeline Mitchell's HBCU Pre-Law Institute to struggle against injustice in society and to reach back into the community to assist those who are less fortunate. I would love for you to go into public interest law. I would love for you to be a movement lawyer, but I also would love for you to be a judge. I would love for you, yes, I would, to be a prosecutor. I would love for you to be a legislator. I would love for you to be a partner in a huge law firm. Why? Because you might be that judge to finally set Sundiata Acoli, or Mumia Abu-Jamal, or Rochelle McGee free. You might be that prosecutor who uses her discretion wisely. You might be that legislator who abolishes mandatory minimum sentences. You might be the governor to grant clemency to Assata Shakur. You might be that law firm partner who finances the posting of bail for any Black Lives Matter protester to get out of jail. And that is what I feel being a public interest lawyer, a movement lawyer, a people's lawyer is all about. Wherever that career path takes you, to pick up the baton from your predecessors and continue the struggle for justice. Pre-law students, I'm not promising that your journey will be easy. But whenever times get hard or you feel stuck, I want you to remember the words of the great warrior woman, Harriet Tubman. Harriet Tubman, who led over 300 people out of enslavement. She simply told her people to keep going. If you hear the dogs, she said, keep going. If you see the torches in the woods, keep going. If they're shouting after you, keep going. Don't stop. If you feel tired, keep going. If you want that taste of freedom, keep going. If you want to get into that law school, keep going. If you want to be a partner in a law firm, keep going. Don't stop. If you want to be a judge, keep going. If you want to practice law in the public interest, keep going. If you want to represent political prisoners, keep going. If you want to mobilize for reparations, keep going. If you want to carry on the tradition of the movement lawyer, keep going, keep going, keep going. Oh! And if you want to hear any more of my personal story, then check out my website, blackpowerbblacklawyer.com. Get a copy of my memoir or visit my personal website, nikicitaifa.com, and see all of my stuff. Let's all keep going, y'all. Thank you very much.